everybody, this is Deb with Truthification Chronicles, and I've got a good document for you today. I love finding these documents that are out there, but the American people just don't seem to be aware of them. And this, I think, is one of them. But before I get into that, I want to clarify something on the demonetization thing. First of all, I like to make sure you know when things are demonetized because that's letting you know what kind of censoring is going on YouTube with conservatives. Now, I have not heard of too many liberals who have been censored like this, where they all of a sudden have these videos demonetized just willy-nilly. And so I want to make sure that you understand that this is happening to conservatives. Secondly, one of the reasons that it ticks me off when they demonetize it is because when they demonetize it, it appears that it doesn't get the reach that the other ones do. And that means it's not like put on the recommended videos very often, or it's not put on that main page when you log in. So I just think that they usually don't promote it as much. Whether I promote it or not, that's different. I'm doing about the same thing for all of them. But I have noticed when they demonetize something, it just doesn't have much traction. And sometimes the topics are very good, but they aren't being picked up. So it could just be a fluke, but that's what I'm observing, so that's what I think probably happens. Anyway, when the Huber video came out, they demonetized it right away, and then sometime in the afternoon, they remonetized it, which is a good thing because now it is getting lots of play, and that's the important part, that the information gets out there. Because people need to know what Huber's doing, and he's going to be testifying this week sometime. Now, I don't know if Bush's funeral is going to affect when that testimony takes place. I can't say. That's kind of out of my control. But it was scheduled for December 5th, which, by the way, is Lieutenant General Mike Flynn's birthday, his 60th birthday. So we'll wish him a happy birthday on Wednesday. So if Huber doesn't testify on Wednesday, it's purely because of that. And it's not like I could control anything, but it was scheduled for Wednesday. So we'll find out what happens. I don't know if they're going to close down the government that day or what, but I do know that's when he was scheduled to testify. So we're just going to see how it plays out. But this document right here is very important right now and very apropos. And I think some of you are going to find this extremely interesting. So let's go through this. Now, this document was made on June 27, 2002. It comes from the Office of the Deputy Assistant Attorney General. So it is kind of official, but it's not really official. What this is a memorandum, which is kind of like the one for Whitaker, where it gives the legal case for a certain thing. And so in this case, this one, Daniel J. Bryant put this down, and it is the applicability of 18 U.S.C. 4001A to military detention of United States citizens. Now, this is going to deal with something that happened right before 2002, the year before. It does have to do with a certain date from the year before that, 2001. I think you all know what I'm talking about. Again, I'm going to try to not mention that very much because that's one of the things that I think they'll probably demonetize for. And again, the demonetization would be bad because it won't get out there as much. And everybody needs to see this. They really do. But a lot of it will come from you sharing, so I hope you will share this with others. You have asked us whether the detention of United States citizens as enemy belligerents by the U.S. Armed Forces violates 18 U.S.C. 4001A 2000. We understand that the question has arisen in briefings before the Senate Judiciary Committee and the Senate Select Committee on Intelligence concerning the recent transfer of Jose Padilla, aka Abdullah al-Mujahir, from the custody of the Department of Justice to the control of the Department of Defense. Section 4001 of Title 18 states, now I know this is a little legal speak here, but stick with me because this is the foundation that they're going to be talking about in the rest of it. A. No citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. B. 1. The control and management of federal penal and correctional institutions, except military and naval institutions, shall be vested in the Attorney General, who shall promulgate rules for the government thereof, and appoint all necessary officers and employees in accordance with the Civil Service laws, the Classification Act as amended, and the applicable regulations. Number 2, the Attorney General may establish and conduct industries, farms, and other activities and classify the inmates and provide for their proper government, discipline, treatment, care, rehabilitation, and reformation. 18 U.S.C. paragraph 4001. As we explained below, the President's authority to detain enemy combatants, including U.S. citizens, is based on his constitutional authority as Commander-in-Chief. We conclude that Section 4001A does not, and constitutionally could not, interfere with that authority. In order to understand the scope of Section 4001A, we first set out the proper context established by the President's authority to detain enemy combatants during war. That authority arises out of the President's constitutional status as Commander-in-Chief. Under the Commander-in-Chief Clause, the President is authorized to detain all enemy combatants, including U.S. citizens. Finally, we note that Congress has specifically authorized the President to use force against enemy combatants in response to the terrorist attack of, but which we're not going to talk about that particular date, but that's what this is all about, okay? Article 2 of the Constitution vests the entirety of the executive power of the United States government in a President of the United States of America, and expressly provides that the President shall be Commander-in-Chief of the Army and Navy of the United States. And then it goes on, because both the executive power and command of the military and naval forces is vested in the President. Because both the executive power and the command of the military and naval forces is vested in the President, the Supreme Court has unanimously stated that it is the President alone who is constitutionally invested with the entire charge of hostile operations. And there's the case for that. As Commander-in-Chief, the President possesses the full powers necessary to prosecute successfully a military campaign. As the Supreme Court has recognized, the first of the enumerated powers of the President is that he shall be Commander-in-Chief of the Army and Navy of the United States. And, of course, grant of war power includes all that is necessary and proper for carrying these powers into execution. And there's the case on that one. I'm telling you, it's got a lot of cases here. So it does have the backing for this. It's just that most of us are not going to be interested in that. I'm getting there. Don't worry. I'm getting there. By their terms, these provisions vest full control of the military operations of the United States in the President. It has long been the view of this office, this office, remember, means the Department of Justice, that the Commander-in-Chief Clause is a substantive grant of authority to the President. And there's a memorandum there, and then we go down after all of these. This authority includes all those powers not expressly delegated by the Constitution to Congress that have traditionally been exercised by Commanders-in-Chief of Armed Forces. One of the core functions of the Commander-in-Chief is that of capturing and detaining members of the enemy. And it says, see this, the Commander-in-Chief Clause constitutes an independent grant of substantive authority to engage in the detention and transfer of prisoners captured in armed conflicts. It is well settled that the President may seize and detain enemy combatants, at least for the duration of the conflict. Numerous presidents, for example, have ordered the capture and detention of enemy combatants during virtually every major conflict in the nation's history, including recent conflicts such as the Gulf, Vietnam, and Korean Wars. Recognizing this authority, Congress never has attempted to restrict or interfere with the President's authority on this score. It is obvious that the current President plainly has authority to detain enemy combatants in connection with the present conflict, just as he has in every previously armed conflict. This was referring to W. Bush. Okay? The Supreme Court has also recognized the President's authority as Commander-in-Chief to order to capture and detention of enemy belligerents. And then here it gives a little thing about it and more legal speak. We should emphasize here that military detention of enemy combatants serves a particular goal, one that is wholly distinct from that of detention of civilians for ordinary law enforcement purposes. I think this is kind of an important point that he's making here. The purpose of law enforcement detention is punitive, to punish individuals, to collect evidence establishing that a crime may have been committed, to ensure that an individual will appear at a criminal trial, or for other related purposes. The purpose of military detention, by contrast, is exclusively preventive. And it goes through, look at this line here. Internment is not a punishment for crime. Belligerent troops are disarmed as soon as they cross the neutral frontier and detained in honorable confinement until the end of the war. As Commander-in-Chief, the President may order the detention of enemy combatants in order to prevent the individual from engaging in further hostilities against the United States, to deprive the enemy of that individual's service, and to collect information helpful to the United States' efforts to prosecute the armed conflict successfully. So, you can see that this is what the purpose was. Down here, while enemy combatants also may be subject to criminal prosecution under United States or international law, and there's the information on that, evidence of criminal liability is legally unnecessary in order for the U.S. Armed Forces to detain an enemy combatant. Check that out. So keep in mind, there's a difference between how military law works and how civilian law works. And in this case, when it's talking about an enemy combatant, evidence of criminal liability is legally unnecessary. You don't even have to prove that they are criminally liable for anything. And so then it goes on. Oops, sorry about that. Oh, bumped it up a little bit. It is also settled that the President's authority to detain an enemy combatant is not diminished by a claim or even a showing of American citizenship. Citizenship in the United States of an enemy belligerent does not relieve him from the consequence of a belligerency which is unlawful. Then it goes on, it says, it is immaterial to the legality of petitioner's detention as a prisoner of war by American military authorities whether petitioner is or is not a citizen of the United States of America. So, the petitioner's citizenship in the United States does not confer upon him any constitutional right not accorded any other belligerent under the laws of war. The fact that a detainee is an American citizen, thus, does not affect the President's constitutional authority as Commander-in-Chief to detain him, once it has been determined that he is an enemy combatant. As the Supreme Court has unanimously held, all individuals, regardless of citizenship, who associate themselves with the military arm of the enemy and with its aid, guidance, and direction enter this country bent on hostile acts are enemy belligerents within the meaning of the Hague Convention and the law of war. Nothing further need be demonstrated to justify their detention as enemy combatants. The individuals need not be caught while engaged in the act of war or captured within the theater of war. And then go down here. They need not be found carrying weapons. Nor must their acts be targeted at our military. So it goes on, and then down here it says, accordingly, all those who during time of war pass surreptitiously from enemy territory into our own, discarding their uniforms upon entry for the commission of hostile acts involving destruction of life or property, have the status of unlawful combatants. Okay, now this was specifically talking about some of the perpetrators of that big day, and at least one of them was claiming U.S. citizenship. So that is why this is being discussed. But keep in mind, there's a bigger picture because we all know what was behind that day, right? For example, in Quirin, several members of the German armed forces who had covertly entered the United States with the objective of committing acts of sabotage were seized and ultimately tried by military commission. The FBI captured the saboteurs within the United States after they had hidden their uniforms and infiltrated into New York and Chicago. The Supreme Court concluded that they were properly held by the military and tried by military commission, even though one of the defendants, Haupt, was allegedly a citizen. Their plans occurred behind the front lines, within states unthreatened by war, and the courts within the United States were operating openly. Ex parte Milligan, 71 U.S. to 1866 does not affect its conclusion. Now, I'm going to sum this up. This happened during the Civil War, and it involved the state of Indiana. So basically, this guy was supporting those from the South, and he lived in Indiana, and he never went out of Indiana. They found out that he had no contact with anybody from the South, so it wasn't like he was directly giving them aid, he was just supporting them. And because of that, they tried to try him for treason, but the conclusion was that he wasn't guilty of treason because he was not actually doing anything to actively help the enemy or aid the enemy, and he'd never been out of Indiana, and Indiana was totally out of the whole fray. It didn't matter what he said, he was just supporting them. That was that case right there. So he's saying that that case really does not have bearing on this. So he spends a lot of time talking about that particular case. And again, I'll leave the link down below. You can look at it yourself. So let me just start here because this is kind of a summary of it. In Quirion, the court clarified and restricted the scope of its earlier holding in Milligan, which was the case in Indiana. The court found that Milligan does not apply to enemy belligerents captured within the United States. The status of the saboteurs in Quirion as enemy belligerents, rather than non-belligerent civilians, was easily determined due to their training in the German Reich, their membership in its marine infantry, their transportation by German submarine, and their initial dress in German uniforms. The court expressly distinguished Milligan on the basis that Milligan had been a civilian and not an enemy belligerent. From the facts of Milligan, the court concluded that Milligan, not being a part of or associated with the armed forces of the enemy, was a non-belligerent, not subject to the law of war, save as, in circumstances found not there to be present and not involved here, martial law might be constitutionally established. So there's the information on that. In some ways, Milligan appeared to be an enemy sympathizer, but he could not really be said to be part of the enemy forces. Because the Nazi saboteurs were belligerents, by contrast, the Quirion court found that Milligan did not apply. We accordingly conclude that, under Milligan and Quirion, the President's constitutional authority as Commander-in-Chief to detain enemy combatants extends to U.S. citizens and non-citizens alike. Finally, we note that the President's constitutional authority to detain enemy combatants during the present conflict is bolstered by Senate Joint Resolution 23, which went into effect on September 18, 2001. That resolution recognizes that the President has authority under the Constitution to take action to deter and prevent acts of international terrorism against the United States. Now, you're probably wondering at this point, what in the world? Why is she going through all this? Well, you're going to see very soon here. And those of you who understand what happened on that big day in 2001, you will know where I'm headed with this, I think. Additionally, the resolution explicitly authorizes the President to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on that date, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. Read that again. Read that again. Additionally, the resolution explicitly authorizes the President to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred that day. Are you getting the picture now? Remember, this was talking about W. Bush, but it's still in effect. Thus, Congress has specifically endorsed the use not only of deadly force, but also of the lesser included authority to detain enemy combatants to prevent them from furthering hostilities against the United States. Okay, I'm going to scroll down to the bottom because basically it goes on from there, and you've got the main idea of hopefully what I'm trying to say here about the president being able to do that. I'm going to go down to where the summary is. Okay, this is basically summarizes what the argument is. As we've already explained, which is what the whole rest of this is, the most reasonable construction of Section 4001A is that it does not restrict the President's constitutional authority as Commander-in-Chief to detain U.S. citizens who are enemy combatants. Any other construction would raise serious constitutional questions. The President's power to detain enemy combatants, including U.S. citizens, arises out of his constitutional authority as Commander-in-Chief. As our office has consistently held during this administration and previous administrations, Congress lacks authority under Article 1 to set the terms and conditions under which the President may exercise his authority as Commander-in-Chief to control the conduct of military operations during the course of a campaign. Congress may no more regulate the President's ability to detain enemy combatants than it may regulate his ability to direct troop movements on the battlefield. Accordingly, we would construe Section 4001A to avoid this constitutional difficulty and conclude that subsection A does not apply to the President's detention of enemy combatants pursuant to his Commander-in-Chief authority. You can go ahead and read the whole thing if you want to. It's 13 pages long. But the heart of it is, it's been confirmed that after the events of that big day in 2001, can indeed detain citizens as enemy combatants if they played a part in planning or implementing the events of a terrorist attack. Now, this was set up for a totally different reason and to actually trap those of us who are patriots. But guess what? The tables are being turned. And this document right here supports the authority that our president has to do this. This is why things are happening like they are, and you're going to see some major movements in the legal aspects of things coming up. We had to have the Supreme Court, because if we didn't have a solid Supreme Court, we wouldn't be able to implement any of this. It wouldn't have done him any good to start doing any of this or taking any action against the people who actually planned that event. And yes, we all know who they were, right? So things are now set up. If Ruth Bader Ginsburg decides to resign, we have the Senate, so we will be able to make sure whoever we want to put in to take her place, a strong conservative, will do that. And more than being a conservative, what we want is somebody who will actually interpret the Constitution as it's written and as it was intended and not make up laws along the way. That's what we really need. So if we get her, that makes it 6-3, and it will set things for 20, 30 years into the future. I mean, it's really important that we had the Senate. It's very important that we maintain the Supreme Court, because that's going to affect how our country goes for the next several years. This is why they're so ticked at our current president, because they needed to hang on to the presidency, because this power right here allows the president to do the things he's about ready to do. So hang in there, patriots. It's coming, and we know what we're going to see in the next few months. Remember, January 1st of 2019 is when the executive order for the court's martial manual update goes into effect, and I think we're going to see some amazing things. So, thanks for stopping by, and I'll see you later.